There you go.
Good afternoon. Welcome to the Heritage Foundation and our Douglas and Sarah Allison Auditorium. We, of course, welcome those who join us on all of these occasions on our heritage.org website. Would ask everyone in-house if you'll make that courtesy check that cell phones have been turned off. It is always appreciated by those recording the events as well as for those speaking. We will post the program within 24 hours on the Heritage homepage for your future reference as well. Our internet viewers, of course, are always asked to send their questions or comments if they have them, simply emailing us at speaker@heritage.org. Hosting our discussion this afternoon is Hans von Spakovsky. He serves as our Senior Legal Fellow in the Center for Legal and Judicial Studies and is manager of our Civil Justice Reform Initiative. He looks at legal aspects of elections such as campaign finance, voter fraud, voter identification laws, as well as registration and equipment issues. He served for 2 years as a member of the Federal Election Commission. He has served as a counsel to the Assistant Attorney General for Civil Rights. He is a former litigator and in-house counsel and senior corporate officer in the insurance industry. And he has served in several positions with boards of advisors on elections and other issues related to elections and registration. Please join me in welcoming my colleague, Hans von Spakovsky.
Well, welcome everyone to the kickoff event, actually, for the Legal Center's 7-part Preserve the Constitution series that celebrates the heritage of our Constitution. The next presentation in the series, by the way, is going to be Friday, September 20th, with the very provocative title of Does Technology Lead to Tyranny? And it's going to take a look at new technology and the protections we all are supposed to enjoy under the Fourth Amendment. I do want to thank the State Government Leadership Foundation. Sarah, Lindsay, you might want to stand up for helping us put this on today. They're our co-sponsors for the event. And to moderate our discussion today about the fight to preserve federalism and to introduce our panelists, we're honored to have Fred Barnes, executive editor of the Weekly Standard. I should say that we had thought of Fred Barnes not just because he's a leading pundit and journalist, but also because he had done a great article, and you can see it right here. I didn't know he brought that. I actually brought my own personal copy of it, called The Last Redoubt. And it's about, and I have to tell you, Fred, you need to tell your folks, this is like one of the cleverest covers I've seen on a magazine with the state AGs in a foxhole where they're fighting the federal government. And his article describes how state AGs have been, like I said, battling the federal government, trying to stop the unconstitutional expansion and invasion of state sovereignty, and trying to stop unreasonable and frankly dictatorial regulations being implemented. At one point in the article, as he says, the AGs, quote, have beaten the best lawyers at the Justice Department numerous times. And that's what they're here to talk about today. As all of you know, Fred Barnes helped found the Weekly Standard along with Bill Kristol and John Podhoretz. In addition to his work at the Weekly Standard, he's a contributor to the Fox News. We all remember his very memorable battles with Mort Kondracki as the co-host of the Beltway Boys. And for many years, he was a regular panelist on the McLaughlin Group, although I have to tell you, Brad, your official biography lists you as a panelist. I actually think you should change that word to combatant for the McLaughlin Group. So, Fred Barnes.
Thanks. I'm delighted to be here. I'm delighted to have written about Republican attorneys general. One of the suggestions I would make is come up with a better plural. Just call them attorney generals. It's so much easier than to have to say attorneys general. Anyway, my advice is rarely taken. I happened to write this article mainly because of one of the AGs, Luther Strange of Alabama, who I've known for 20 years, and his assistant Kevin Turner, who's sitting there, and just hearing about all the things that Republican attorneys general were doing all over the country. And it was really remarkable. Nobody else had written about it, and so I decided I would, and it was, Hans, you're right, it was helped by a great cover. And I learned a lot, managed to go and see some of the AGs. I saw Scott Pruitt in Oklahoma and others I interviewed here. Anyway, I'm not going to talk much about this. Let me read you 3 sentences and no more from what I wrote in the article. about the Republican AGs, and the 4 here were all elected in 2010, which is important because they're the future. And they're quite different from what Republican AGs, as I remember them, being in journalism a long time, over the years, who were a pretty, well, they were not activists, that's for sure. Whatever the antonym of activists is, that's what they were, or many of them were. Anyway, here's what I wrote. The AGs, who often attack the administration, that's the Obama administration and PACs, have done more than Republicans in Congress, state houses, or anywhere else to block, cripple, undermine, or weaken Obama's initiatives. They failed to stop Obamacare in the Supreme Court, but won limits on Medicaid and neutralized the use of the Commerce Clause to expand the reach of the federal government. Okay, that's 2 sentences. In effect, the administration has been put on notice. If you adopt policies inconsistent with constitutional limits and the rule of law, Republican attorneys general will come after you. And that's what they're going to talk about. I'm going to introduce them. I hate long introductions, so I'm going to introduce them very, very briefly. On the far end there is Scott Pruitt of Oklahoma, who has won, he's been in politics, was in the state Senate, was also the general managing partner of the Oklahoma Red Hawks AAA baseball team. Now, why he would give that up to become Republican Attorney General is anybody's guess, but he has been very active. They'll talk about the different areas, whether it's EPA or Obamacare. They're all involved in Obamacare, and other efforts against the encroachment on the states and on individual liberty as well by the Obama administration. Then there's Luther Strange, who I've known so long, used to live here in Washington, and my son and his son are great friends. That's how we got to know each other. Luther is now the lead attorney, I guess that's not the exact title, in dealing with the BP spill case, which is still going on. Luther tells me that BP is trying to get out of the agreement, which all the money they promised to hand over a while back. Then we have Derek Schmidt. I was reading a piece about him, and it said he majored in journalism at the University of Kansas. Boy, you were smart to leave that field. I'll have to say, when he came into office, the first thing he did, correct me if I'm wrong about this, Derek, the first thing he did was join the Obamacare suit.
Yeah, that's true.
And we know a great deal about that suit. And lastly is Alan Wilson, whose father, Joe Wilson, the congressman from the 2nd District in South Carolina, is sitting over there. And Alan is a very colorful guy. One of the things I recommend you do with him, as I did, is to go to YouTube and look up speeches by Alan Wilson, particularly when he talks about the blob. The blob, well, I won't tell you any more about it, but it's certainly something you ought to do. I did with great pleasure, for sure. Why don't we start with you, Scott?
Okay. I thought I was batting cleanup today. No. It's a joy to be here. I want to say first, thanks to Heritage. Participated in this panel last year. It's wonderful to be here. These are very important topics that we're going to be discussing, and I appreciate Hans's leadership. General Meese led the panel last year, and it's always a pleasure to be at Heritage. It's always a pleasure to be here talking about issues of federalism. I also want to say thank you to Fred for moderating the panel today, and we do appreciate the article and the story that was told there, and also to my colleagues. These colleagues up here are friends of mine. We work together on many issues, but they are dear friends. And as Fred indicated, we all came in 2010, and so we have become very close over the last 3 years, and looking forward to working with them in the years ahead. You know, if I began, which I will, this discussion with a comment, it's fairly provocative, since Fred said, you know, maybe there's some provocative things that were in the article. You know, if I said we were living in the midst of a constitutional crisis right now in this country, would you believe it? And the reason I start with that is because when you look at the Article 2, authority and responsibility of the president, this faithful execution of the laws is something that we're going to talk about quite a bit today. It's not a matter of opinion. It really is a matter of fact that this administration, this executive branch, has acted inconsistent with its responsibility to faithfully execute the laws. I mean, when you think about the employer mandate, The employer mandate was a shall, not a may, that existed in the Affordable Care Act, and this administration, by executive action through agencies, simply disregarded it and delayed it more than a year. The caps that are in place for individuals under the law on out-of-pocket expenditures was simply removed and delayed and not enforced. This administration did that. When you look at the work requirements from the Welfare Reform Act of 1996, when you look at the immigration issue from last year, there are many examples. In fact, the Congressional Research Service recently published a paper on the many ways that the Affordable Care Act has been amended, rescinded, or repealed. 19 times it's happened, 14 times by Congress, 5 times by the executive branch. All of us in this room ought to be very concerned. All of us in this room ought to be very interested in making sure, whether it's a Republican or a Democrat that's in the White House, that the president and the executive acts consistent with its responsibility under the law. And so what we're talking about here today are some examples, and I'm going to mention a couple to you, but I would say to you that the Constitution's in the hands of this president is a very dangerous thing. And again, that's not a matter of editorial comment. I believe it's a matter of fact. Now, with respect to the healthcare law, Fred mentioned this, like Derek Schmidt, the state of Oklahoma was not a part of the original ACA challenge that was initiated by the collection of states. So after being sworn in January of 2011, it was not a matter of whether to engage, it was a matter of how to engage. In Oklahoma, I made the decision to file a separate action. Filed that in the Eastern District of Oklahoma in the federal court there, and largely because we had passed a constitutional amendment in the state in November of 10, basically saying that the individual mandate could not be applied in the state of Oklahoma, so it was a conflict with federal law. And I thought it best to defend the Oklahoma Constitution before an Oklahoma judge. Imagine that. But brought that action in Oklahoma, and in our case, the Oklahoma's case was stayed shortly thereafter because the other case was on its way up to the Supreme Court, which ultimately led to the NFIB decision in June of last year. But because our case was still pending in district court in Oklahoma, we had something that no other state had, the ability to amend our lawsuit. Because it was not at the circuit court level, we could look at our case and determine, are there issues that were not resolved in NFIB versus Sebelius, or were there areas of implementation? You know, there's been much discussion here in D.C. In fact, I was in Congress about a month ago testifying before one of the committees about our lawsuit, and some of the folks on the panel said, why can't we just get over this? The case has been litigated, it's been resolved, the Supreme Court has spoken. The Supreme Court has spoken about one issue, the facial constitutionality of the law. It has not spoken as it relates to the implementation of the law. And there are many issues related to the implementation. The contraceptive mandate, the Hobby Lobby case, that Hobby Lobby is a company that's based in Oklahoma. That's an area of implementation with HHS. The case in Oklahoma is about one rule, the rule that the IRS passed in May of 2012. And under the law, the Affordable Care Act gives the states, this is an opinion again, it's not editorial comment, it gives authority to the states to make the decision about whether to adopt a state healthcare exchange. It's reserved explicitly to the states. And the state of Oklahoma, along with 33 other states, have chosen not to set up a state healthcare exchange. And under the law, section 1401 of the statutes, it says that the subsidies that people can qualify for, between 100 and 400% of federal poverty, that those subsidies will flow through the state healthcare exchange. Congress was very intentional about saying that, and the corresponding penalty would also flow through the state healthcare exchange. So when the IRS passed their rule in May of 2012, they did something pretty important. They disregarded the statute. They said whether a state has set up an exchange or not doesn't matter. We're going to apply the subsidies and we're going to apply the penalties in all 50 states, irrespective of whether the states have chosen to set up an exchange or not. The only problem with that position is it's against the plain reading of the statute. The agency is trying to improve upon the statute from their perspective, and that's not their role. So Oklahoma amended the lawsuit. I amended the lawsuit in September of last year and said, you're not going to do that in Oklahoma, and we initiated that in September and amended it. We've been litigating it, and there was recently a motion to dismiss that Judge White ruled upon that said that the state of Oklahoma has standing to pursue the case. Very encouraged by that. Very excited about that opportunity because I think on the merits, Oklahoma, the 33 other states that have made a decision not to set up an exchange are in a good position. Now, why is this important? Well, I understand there's been a lot of discussion here in Washington about defunding the Affordable Care Act. Is that true, Fred? I think there's been some discussion about that. But when you look at that discussion in Congress, Forbes did an article, about 3 weeks ago, and said, with all the discussion about defunding the Affordable Care Act, if Oklahoma is successful, the entire structure of the Affordable Care Act will fall, because the precedent will be set and the IRS will not be able to assess the penalty in 34 states. And so the ability to enforce the law under the employer mandate will be affected in a substantial way. Now, that was not the motive. That was not why Oklahoma brought the decision. The reason we brought the case, is because the IRS disregarded the statute and is seeking to take away a decision that Oklahoma has made. If the IRS can come in and disregard the statute, though Congress has reserved that to the states, we really don't have a decision. And that's what's at issue with the healthcare lawsuit. One other case that I'm going to talk about is the Regional Hayes case. You know, environmental laws, and this is something for those in the room that practice in that area, you know that with the environmental laws of our country, cooperative federalism was really a focal point from the very beginning. When President Nixon set up the EPA in the early 1970s, and then the Clean Air Act and others following that, Congress was very intentional about reserving a role for the states to work with the EPA and the federal government to accomplish the ends that were identified in the respective environmental laws. And under the Clean Air Act, it's no different. Under the Clean Air Act, there's a program called the Regional Hayes Program. And Regional Hayes is an aesthetics or a visibility standard, not safety and health. And so Congress was even more intentional. They said when it comes to aesthetics and visibility, the states actually can engage in a cost-benefit analysis to determine whether there's sufficient benefit with investment in achieving goals under the statute. The Regional Hayes Program says that by the year 2064, in the state of Oklahoma and the Wichita Mountains, we're supposed to achieve natural visibility in that Class 1 federally designated area. We submitted a plan in 2010 to do that. In fact, it beat the deadline by more than 15 years. Lisa Jackson, when she was still leading the EPA, came into the state in March of 11 and said, I don't like your plan. And she didn't like the plan primarily because we didn't get rid of fossil fuels. And they rejected the state plan and said, we're going to force a federal plan upon the state of Oklahoma. And it was a pretty significant thing because it was a cost to the utilities of our state, roughly $2 to $2.5 billion over a 3-year period, which would have caused utility rates to go up 20% almost in that 3-year period and annually thereafter. Lisa Jackson completely, when she came in and kicked out the state plan and forced a federal plan upon the state, did so inconsistent with the plain reading of the statute again. Because under the statute, it says that states have primacy or primary in adopting a plan. So those are two examples where I believe that the states, Oklahoma particularly, have made decisions that Congress has said we have the authority to make in the cooperative federalism arrangement. We've made them, and agency action, postscript to our decision, seeks to take the decision away. Again, contrary to the plain reading of the statute. I'll end with this, and I think this is very important to say. These cases that I'm a part of, that Oklahoma is a part of, is not intended to be a political or a policy statement. You know, I owned a business, as Fred indicated, for 8+ years, and I love the baseball business, Fred. And I experienced medical inflation as a business owner, roughly 15% a year. It's worse than that now. It's probably 20 to 25% a year for business folks. I understand what it means to pay and access health care on behalf of employees. We need to have a discussion on how to do that better, both at state and federal level. It's not intended to be a political statement. You know, just like the original ACA lawsuit in March of 2010, when my friend Ken Cuccinelli from Virginia brought the first lawsuit, what was the accusation then? You're just doing this to make the administration look bad. You're just doing this because it's an election year in March of 2010. And as Fred indicated, 2 years later, it was quite vindicating to sit in the Supreme Court and hear Justice Scalia and Justice Kennedy and Justice Alito and others ask the very same questions that attorneys general have been asking for 2 years. And we did get some victories out of that lawsuit, as Fred indicated. This is not intended to be political. It's not intended to be policy. It's intended to be about one thing. We ought to care about rule of law in this country. And if an agency that exists to administer law acts in a super legislative way, then our representative democracy breaks down. And the AGs at the state level, in my estimation, are the first line and the last line of defense at giving life and meaning to the Constitution and the laws as they've been passed by Congress. So it's an honor to serve with these fellows and others that we walk with. But I reach out, as they will tell you, often to Democrats to say, you should join us. Because Democrats and Republicans both ought to be concerned about rule of law and making sure that the laws are enforced as they've been passed by Congress and as the Constitution dictates. So with that, I'll hand it to my tall friend, Luther Strange, maybe.
Yeah, let me intercede.
Maybe not Fred. I always kind of kid Luther, they put them beside each other often.
I'll get to
Because
Luther in just a second. Am I right in that there was one Democrat and one Democratic AG who joined the Obamacare suit, but then he became a Republican?
He was persuaded, yes.
What the drill is here, all four are going to speak, obviously, and then I'm going to ask a question or two, maybe only one, and then we'll hope to have time, assuming there are no filibusters up here, for you all to ask a few questions. Anyway, Luther?
Okay, thanks. Well, Scott's the point guard, and he's making a pass, which none of my point guards ever did to me with the ball. And I could never get one to pass the ball. But thank you for doing that. And thanks, Fred, for agreeing to do this. Your article is a great summary of just some of the issues we're all involved in, and my colleagues as well. I really appreciate this opportunity. Scott has really, I think, teed up the issues, the issue of the rule of law, why it's so important. We all took an oath to uphold the Constitution of the United States of America, of our own states, and of the laws, and make sure they're faithfully executed. We don't make policy. We enforce the rule of law, which is the fundamental tenet that makes this country the country that it is. And I could talk about a lot of issues. I won't talk to many, but I've got one in particular, and it has relevance to Alabama, but it's a fundamental challenge to one of our basic liberties, and that's the freedom of religion, one of our first freedoms under the Constitution. And it comes out of the Affordable Care Act. And as we might have expected, and most people anticipated, there were bound to be unintended consequences when the administration and Congress reordered 1/6 of our economy. And there have been many. Many were intended, many more unintended. But one is of particular interest to me, and it comes out of the Affordable Care Act's healthcare mandate, HHS, so-called HHS mandate, requiring people, companies who would provide insurance to provide services for contraception, morning after pills, and that sort of thing. We have in Alabama an organization you may be familiar with. If you're Catholic, you're certainly familiar with it, but it's the Eternal Word Television Network, EWTN. Mother Angelica, if you've never had the pleasure of watching one of her talks on that station, it happens to be the largest religious broadcasting network in the world. It's in Irondale, Alabama, which is about 5 or 6 miles from where I grew up, behind a beautiful hedge. It's a sort of almost a cloistered community, but it employs several hundred people that broadcast in dozens of languages every day around the world. And if you were watching the selection of the new Pope, you had all Pope all the time on EWTN. It is a very well-known international broadcasting institution, and it's based on the tenets. It's run based on the tenets of the Catholic Church. It's not supported by the Catholic Church. It received no money from the church, but it obviously follows its tenets and the things that it does, it says, and does, and the way it's organized. So, how does that come around to the Affordable Care Act? Well, the Affordable Care Act, HHS mandate provision, said to EWTN, you're going to have to provide contraceptive products and morning after pills and so forth, and the insurance that you provide for your employees. Now, not all the employees are Catholic. They're from all denominations, but they are happily employed there, and they have a very robust insurance plan. As a matter of fact, EWTN went out of their way to self-insure in a manner that has a very good policy. They just don't cover contraception based on their religious position on that. So now, under the Affordable Care Act, they're under the mandate, HHS mandate, they're required to provide it. So what are their choices now? They can either provide it, which would violate their religious beliefs. They cannot provide it and continue to provide insurance and have to pay a huge fine, or they can just drop insurance coverage from all those employees, at which point the state of Alabama would presumably have to pick up some of those costs as those people come into that system. It's a direct threat to religious liberty, and it is a reflection of the administration's position that your religious freedom is fine so far as it goes in the church where you worship. You can go into your church and worship as you like, but once you go out into the real world and you want to apply your religious beliefs, you can't do that. You're no longer allowed to do that. And that's absolutely contrary to the law and the fundamental principles in that first freedom of religion. So we have joined with EWTN, and we've tried to persuade HHS to accommodate EWTN. And they have so far not done that. They've recently come back out and claimed that they did. They haven't. So we're working very closely with EWTN, and we're going to file a lawsuit with them challenging this mandate. It's very closely tied to the case that Scott alluded to, the Hobby Lobby case in Oklahoma, which is a private business with a religious philosophy behind it, which also objects to this mandate. They're in the court in Oklahoma, and they have been making good progress, I'm proud to say. But it's a fundamental constitutional right that's truly under assault here, and there's really no reason for it, really, except for a overreaching philosophy of this government that they're going to tell people, even in areas that are reserved for precious freedoms like religion, how they're going to behave and act. And so we're absolutely, stay tuned for this. The lawsuit's being prepared now. It will be one. There will be many more unintended consequences that will come out of that act and others that are now before this administration. But this is one that I wish you would keep your eye on. Another one, Fred, before I turn it over, is one that's just caught my eye. It'll come to Alabama sooner or later, but it's also it's just troubling to me, and this involves a case in Louisiana. Louisiana, like Alabama, recently has passed laws giving children who are trapped in failing schools a lifeline, an option for a scholarship. In Alabama, it's called the Accountability Act to get kids out of these schools. In Louisiana, they have essentially a voucher program that works this way. It's recently been improved, even strengthened, to give kids that qualify without any racial discrimination whatsoever the ability to get a voucher and to go to a school that's better. It's a lifeline for these kids. The Department of Justice has filed suit against Louisiana saying that they cannot do that. They have to get rid of that school because it'll somehow impact the 50-year-old desegregation orders that are in place, theoretically, to avoid discrimination in these schools. And Bobby Jindal's done a great job of highlighting that issue. Even, and this kind of troubled me, but even the Washington Post has written an editorial saying how silly that is, that we've come to that point. That the Department of Justice is taking that kind of position. But keep an eye on that. It will also be one that I'll be interested in, probably have to deal with in Alabama.
Thank you, Luther. Derek?
Great. Well, thank you. And let me add a couple of particular bits of thought to this overarching framework of why we're here that Scott and Luther have already articulated. And the only thing I would add to perhaps the commentary on the framework, and I think all of my colleagues would agree with this, I certainly, and I believe all of us, and I don't think this is necessarily a partisan limitation, believe that the states really are full partners in the federal system. That the federal system is not a one-directional relationship between the central government and Washington and the various state capitals. And that it was intended to be that way from the inception. Obviously, things have ebbed and flowed over time as history has unfolded and political support and public expectations have unfolded, but that basic concept hasn't changed. And at least for Kansas, and I think for many of us, it's what animates me as we look at these fact circumstances, case by case, which have perhaps always been there to some extent in our federal system, but are much more pronounced, I believe, in many areas over the past handful of years than they have been for many, many years. Essentially, it's an effort, a deliberate effort, to change a two-way relationship of full partners into a one-way relationship of one superior entity and states that are subservient. And that's what we're pushing back against. And I would echo Scott Pruitt's notion that, at least from my vantage point, and I think this is fairly widely spread, I say this a lot at home, I don't view the role of the Kansas Attorney General in these sorts of issues as being just another layer of policymakers or political actors in the system. I view our role as being enforcers or policers of the boundary of that two-way federal system. Or to put it another way, when we figure out which of these sorts of issues we're going to engage on, I leave it to our state senators and members of Congress to decide if it's bad for Kansas and they need to raise Cain about it, God bless them, go forth and do it. We look at it as, is it bad for Kansas and should we raise Cain about it? And then we have the second test, which is, and is there a good, solid legal basis for Kansas to engage in pushing back on that issue, which fits into this broader narrative, but isn't a substitute for the political back and forth and dynamic that we've had throughout American history. So that's sort of the framework in which we look at it. Having said that, let me highlight a couple of issues sort of in the environmental and energy basket where we have chosen in Kansas to engage in that legal pushback against what we think is unlawful federal overreach. And I want to compare and contrast the two examples because one of them has turned out to be relatively partisan in terms of how the battle lines have been drawn, and the other entirely not so. And I think that makes a nice comparison. We're all familiar with the one-line description of those who object to some of the EPA's activities in terms of this war on coal. I'll leave the war on coal phrase to others to debate the merits and demerits of that. But within that, at least from our vantage point, I think it is indisputable, and I believe it is not in dispute, that under that umbrella, which is a policy-driven political choice, given the inability of the executive administration here in Washington to convince a sufficient majority of independently elected members of Congress, particularly in the U.S. Senate with the cap and trade debate a number of years ago, their inability to persuade a sufficient constitutional number of the legislative branch to go along politically with changing the direction of federal regulation in terms of coal-generated power. The administration has now abandoned that as an unsuccessful political strategy and instead has wound up their agencies, particularly the U.S. EPA, to in rifle-shot fashion cascade regulations one upon another that taken together are likely to have the same policy outcome, which is to discourage or eliminate the ability to use fossil fuels and particularly coal for the generation of power. That matters a lot to us in the central part of the country because we are disproportionately reliant upon fossil fuels as our baseload generation. Or to put it another way, as I heard one of our U.S. senators describe it once, and I think it was fairly apt from our regional standpoint, the proposal for cap and trade, and now for cap and trade by other means, through the regulatory and bureaucratic state as opposed to through democratic processes, is actually a proposal for the largest transfer of wealth from the central part of the United States, where we are disproportionately reliant upon fossil fuels to generate our power, to the coasts ever proposed in American history. And I think it is a remarkable effort that if that is true, and I believe that I think it is true, and whether it is true or not, it certainly has elements of truth in it, that debate has instead sort of been slogged down in acronym-laden discussions about individual lawsuits on everything from MATS to CASPR. Let me mention CASPR. CASPR is the cross-state air pollution rule. It is one of a basket of regulations promulgated by the U.S. EPA, I believe in the spirit of obtaining cap and trade by other means, but for whatever reason it was promulgated, it was promulgated. I won't bore you with the Kansas-specific history, but suffice it to say that this is not a situation where my state was simply taken by surprise when the rule came down and was ill-prepared. To the contrary, we had been repeatedly assured over years of conversational engagement with federal administrations that Kansas, based on the scientific data, was not going to be among those states that were regulated under CASPR. So we didn't anticipate that this was going to be a problem that we had to deal with from a state standpoint. Well, guess what? The rule comes down, and guess who is in the basket of regulated states? By the way, the science that was articulated to us for why we were regulated, because of course we're talking here about emissions that drift to other states. The alleged environmental harm, actually in our case, isn't alleged to occur in Kansas or in any state that adjoins Kansas. It's alleged to drift far and wide and to occur elsewhere. They first told us that the harm was in Texas. I believe it was in the Dallas-Fort Worth metropolitan area, which suggested to us in sort of a non-scientific basis that it was a problem driven by northerly winds. Something that caught our attention, since the word Kansas is a Kaw Indian term that means people of the south wind, we were surprised by that. And when we had our folks in the scientific community look at it, they ultimately concluded the data doesn't support that conclusion. They convinced EPA of that, and EPA ultimately withdrew the notion that the harm we were allegedly causing was somehow to our south in Dallas. That didn't, however, cause them to, didn't impede their efforts to include Kansas in the regulated group of states, and instead they now allege that we've caused some harm. I think it's in Kentucky and Michigan, if I remember correctly. I can't recall precisely. In any event, they got the wind direction straight, but the science, we think, is still suspect. We are quite sure the law is suspect because Kansas, like any state, has process rights under the Federal Administrative Procedures Act and otherwise. The federal government, much as it might like to, can't simply say, we got the votes, we got the power, and states will now do our will. And so we challenge that. Kansas was the first state to file suit against EPA challenging the implementation of the cross-state air pollution rule, the transport rules it's sometimes called. There ultimately were a number of other states that joined in. We wound up with, I believe it was a total of 14 states on our side. There are states on the other side that for either political, scientific, or local parochial reasons want to see things different. This tends to be a regional issue for the reasons I articulated earlier. And we've slugged it out. So far, the courts have seen things our way. We prevailed in the D.C. Circuit at the panel. We prevailed in the full D.C. Circuit. EPA petitioned for cert. The Supreme Court granted it. We're in the process of briefing it up, and we anticipate arguing that sometime in the coming months. But the point is when you cut through all of it, sort of masked in this acronym-laden environmental jargon that tends to be viewed as inside baseball, is, in our view, an unlawful effort to impose central will on states that historically have been full partners in this effort of figuring out how we're going to achieve our common goal of protecting the environment that we all live in. That's point number one. Contrast that with number two. My friend Scott Pruitt has been our leader on this effort to really shed some light on the so-called sue and settle strategy that often is used in citizen-generated lawsuits. Scott's done a great job of asking on behalf of many of us for information from US EPA about conversations they may or perhaps may not have had with outside organizations that ultimately bring citizen suits seeking to compel EPA to do what we believe they often want to do anyway. He hasn't had satisfaction in that, and a group of us have now filed a federal lawsuit with his leadership in Oklahoma under the Freedom of Information Act, saying we're entitled to see the documents and we're anxious to see what is ultimately produced in that. But getting past the FOIA issue and down to the merits on this thing, here is what I think the problem is on this sue and settle strategy. Woven into the fabric of our environmental statutes, at least many of them since they were born, many of them in the 70s and 60s, around there, was this concept of empowering citizens to go forth and be independent attorneys general, if you will, and bring suit if the federal government fails to act in order to protect our environment. That was a policy choice made by Congress, and for better or for worse, it is part of the law, and I certainly don't dispute that policy choice. But there is a certain Orwellian irony today that these so-called citizen suits that were designed to empower citizens are being used in a perverse way to disenfranchise citizens, exactly the opposite of what their policy intent was. We see that repeatedly in conduct where EPA, we believe, wants to act, and whatever their desires are in terms of extending federal regulation, whatever their desires are, EPA is in a position where they then get sued by an outside organization that presumably, based on everybody's history, is friendly to the policy outcome that's sought. In a citizen suit, it's a special interest outside group citizen suit, where everybody in the courtroom wants EPA to lose, because that's the goal, to get a federal court order telling EPA to do what we believe they ultimately desire to do anyway. And there is nobody in the courtroom defending the other side of the equation, which presumably has considerable stick to it, or else EPA would simply do what they wanted to do anyway. There's a reason in these cases they haven't chosen to act, whether it's political will or otherwise. A perfect example of that's a suit that Kansas is involved in. It's in federal district court in New Orleans. We don't litigate a lot of cases on behalf of Kansas in federal district court in New Orleans, but this one has huge implications for us and for all of the states in the Mississippi Basin region. The caption is Gulf Restoration Network versus Jackson, and it was a citizen suit under the Clean Water Act relating to total maximum daily loads of certain nutrients, not toxins, but nutrients, entering the Mississippi Basin and ultimately dumping into the Gulf of Mexico. I don't think there is dispute, nor has there been for perhaps a generation now, that dealing with nutrient management and runoff, whether it's from farm fields or whether it's from suburban lawns that have been over-fertilized, is a good, desirable, and appropriate thing to do. But the goal of this particular citizen suit, again, back in the acronym-laden, hope nobody notices sort of approach, is to seek a federal court order that would compel EPA, headquarters here in Washington, this is not merely a regional issue, to fundamentally transform how they approach the regulation of nutrient runoff. And what they're seeking is a transformation from something they call the narrative standard, which is essentially we're all going to work together, states, private entities, and the federal government, to make sure we don't have too much nutrient in the waterway that causes certain harms. We narrate what we're doing, to a numeric standard, not more than certain parts per million or billion or whatever the right measurement is of a certain nutrient in the waterway. What does that mean? If you're engaged in a narrative standard, you have a conversation, you develop the narration. States are inherently involved, and that's what we've done until now. If you're engaged in a numeric regulation of a certain product, somebody has to pick the number. And I will guarantee you it will not be the states that wind up choosing what the number is. It will be a centralization of the regulation of water runoff throughout the Mississippi Basin. And guess what? I don't think it is possible to manage runoff without also managing land use decisions. So if you believe in property rights, as many of us do, and if you believe that property rights ought to be protected first privately, then locally, then at the state level, this is an effort to leapfrog all of that and to centralize in Washington at an agency the ability to manage land use in the Midwest. The stakes are enormous. And by the way, if you look at the states pushing back on that, and all the states that have engaged in this litigation are lined up on the same side, this isn't a case where you have states on both sides. They are states of Republican and Democrat governors. They are states that are blue and red in terms of their overall voting behavior, and they are states of Republican and Democrat attorneys general. It is not a partisan issue. It is an enormous power grab. We think it's illegal, and we're pushing back. And of course, I always like to point out, technically, we're on EPA's side in this one, so we're balanced. Thank you.
Good. Thank you, Derek. Alan?
Well, first off, Hans, thank you so much. Fred, we appreciate all of you hosting this. I would encourage all of you to read the Newsweek article that's displayed behind us. As I tell my friends in South Carolina, and I'll tell you, if you haven't read it, you should. You'll laugh, you'll cry. It's better than Cats. It's riveting. I strongly recommend it. Fred mentioned earlier about a perception of activism from the Republican AG specifically, and I think I mentioned this in the article. That it can be perceived as activism, but I tell people I'm not an activist, I'm a reactivist, because nearly every major position I've taken in regards to a federalism issue with the federal government has been in reaction to something that the federal government has done to the state of South Carolina, and as they've done to my colleague states in return. I tell people all the time that it is easy to say you're being political by taking a position, but if that is the case, whether it is challenging a federal law or defending a state law that is challenged by the federal government, then the inverse is true. For me to take a position is political. For me to do nothing is political. Therefore, I have to rely strictly on the law, hug the law, and cling to it tightly, and that's what I believe we do as AGs. It is not unconstitutional for a government to pass a law that is bad policy, but if that government passes a law that runs afoul of the Constitution or runs afoul of the law itself, it is our duty, it is our mandate, our obligation to our state and federal constitutions to represent our states, because that is our client. Earlier, Fred teased at me about my blob analogy, and I won't do my blob analogy, and if someone wants to ask me in the Q&A period, I'm happy to do it. It is cute, and it is very elementary, but it illustrates a point. But I will skip the blob analogy, and if you want to ask me about it, you're welcome to. But I want to go straight to a few issues that South Carolina has dealt with. And again, reiterate, this is a reactivist position that I'm taking. In regards to the National Labor Relations Board, my first month in office, I got my first letter from the federal government. It was from the National Labor Relations Board, and it was in view of a constitutional amendment that was passed on a ballot, on the same ballot that I was on when I was elected in 2010 regarding card check. It was a union issue where basically it ostensibly says that a person's right to vote to be in a union or not be in a union should be between them and their God, not them and a union boss or a union representative. That ballot in our state constitution passed with 86% of the vote. Now, I got elected with 54% of the vote. That tells me this is not a political or partisan issue. This is a values-based issue. In South Carolina, most Democrats that I know that are friends of mine would agree with the statement that we are a right-to-work state. Now, others may disagree with that philosophy, and that's fine. Go to a union state. But our people passed a ballot that was being challenged by the National Labor Relations Board at the prompting of union folks. They ultimately did not pursue that. They pursued it in other states with what I believe to be a more favorable court system. So I thought I was done with the National Labor Relations Board. A few months later, after that, as y'all know, a very small airplane manufacturing company located in South Carolina, I should say expanded, Boeing, expanded its operation to North Charleston in South Carolina. And I use the word expanded because what Boeing did is that it basically expanded an operation from Washington State to North Charleston, South Carolina. while the expansion to another state was going on, they also expanded their operation and created additional jobs in Washington state. The Machinists Union prompted the National Labor Relations Board to challenge Boeing's in that expansion to South Carolina as violating the National Labor Relations Act. Now, Boeing had to make the best business decision that it could make. It had a $900 million incentive package. It was wooed by South Carolina. It was up in the free market for other states to compete, and it is located in other states. But Boeing decided to expand its operation to manufacture planes in South Carolina. When it got challenged, that concerned me greatly because as I talked to business leaders around the country and even some representatives who have business entities around the world, what I got back from them was, this is sending a message to other companies that, A, we don't want to come to America, because if we do, especially if we land in a union state, it's like a Roach Motel. You can check in, but you can't check out. That is the concern, is that it chases businesses away because businesses want to be able to make a decision that is in their best interest, and so that they can reallocate capital in places that they feel like they can grow their business and create jobs. And it's capital that creates jobs. So that was the first concern I had. So the National Labor Relations Board is an entity that was created over in the mid-1930s at a time when we didn't have sufficient federal or state law to protect the workforce and those people who were prey of unscrupulous businessmen. Times have changed. We have evolved as a society, and unfortunately, and I'm not anti-union, but I'm anti to things what the union does. And if they have a product that is worth selling to the employees in the workforce, and they should be able to do it in an open, transparent way, and people should not be compelled to join a union as a condition of employment. That is where I dispute with the unions. If the unions want to compete in the open marketplace, come on in, the water's just fine. Another issue that I had during my last 2.5 years was an issue, and this goes back to following the rule of law. Yucca Mountain was designated by Congress in 2002 as our national repository for nuclear waste. My friends in Nevada don't want it there. They have every right to contest that, and I don't dispute that they should contest it if that's how they feel. My comments are not on the merits of whether Yucca should be in Nevada or be in somewhere else. My comments are to the rule of law. In 1983, Congress and the President passed and signed the Nuclear Waste Policy Act, which basically enabled utility companies from around the country to start collecting fees from consumers. 1/10 of 1 cent of every kilowatt hour used, to the tune of $31 billion over 3 decades, was collected for the purposes of exploring and doing environmental impact studies on a place to store national nuclear waste. The area of Yucca is the most researched and studied real estate in the history of the planet. In 2010, the Department of Energy unilaterally, while it was under review by the Nuclear Regulatory Commission, unilaterally pulled the application. By law, it was supposed to go through an application process where it can be given an up or a down based on the science. It was unilaterally pulled off the table for political purposes, and it didn't even get a chance to run its course. Now, whether you agree or disagree, the issue here is that the federal government said to the states, thank you for the $31 billion you've given us, but you can still keep your waste. We did not get the benefit of our bargain. So ratepayers got stuck with the bill that they had been paying for the last 2.5 decades, but it wasn't just ratepayers, taxpayers. When you look at the judgments levied against the federal government for violating their contracts, it's in excess of $2 billion. $200 million in legal fees over that same amount of time have been paid and borne by the taxpayers. So I was happy when a federal appeals court basically said that the Department of Energy and this administration ran afoul of the law by withdrawing Yucca's application, and they have now put it back on track to be considered so that it can run its course. Again, we have spent $15 billion. $15 billion. We built a 6-mile road, a long road through the middle of a mountain in the middle of the desert, 100 miles northwest of Las Vegas, and that application was pulled because folks from that area of the country just didn't want it there. Again, if they didn't want it there, there was a process by which they could contest and fight it, but just by circumventing the law was not an appropriate process, in my opinion. The last area I want to touch on, and I'm touching quickly on the issues that have affected my state because we don't have a lot of time, but that was the voter ID. The Voting Rights Act, like the National Labor Relations Act, does a lot of good. And in fact, I'm a huge supporter of the VRA, and I'm a huge supporter of a lot of the provisions under the VRA, and some of them that were passed nearly 50 years ago were necessary at the time to combat evils that were pervasive in certain areas of the country, including my home state of South Carolina. The problem is that the formula used in 1964 and ultimately 68 and 72 were static. Every state that was under a covered jurisdiction under the Voting Rights Act, and by covered jurisdiction means they have to go to the federal government to ask permission before they can implement an election law that's passed in their state. Every state that fell under that formula would not fall under that formula if we were using modern day numbers. So they're basically saying, South Carolina, we're judging you on conduct that you did back in 1964, 68, and 72. Ladies and gentlemen, the last time that the formula was touched for my state, I was in utero. I wasn't even born. It was 1972. I was born in 73. They're still using the same formula. When our legislature and our governor passed and signed the voter ID bill, many people debated the merits of the bill. Was it a necessary bill? What were the intentions of people who passed it? Race was interjected into into this issue, and it's unfortunate because I didn't see it as a race issue. I saw it as a legal issue. Now, many reasonable people can disagree as to whether it's a needed law or unneeded law, but the point is, I look to the precedent set by the Supreme Court, by federal courts. I looked at uncovered states that had passed similar laws, covered states that had been pre-approved in years past, and I looked at South Carolina's law. South Carolina's law was a sound law from the point of view of protecting the integrity of all voters, regardless of their race or ethnicity or anything like that. We got a unilateral across-the-board plus a thumbs up from the Court of Appeals here in D.C. saying that South Carolina's law protected the sanctity of the voters and their rights while preserving the integrity of the election system. Agree or disagree with the merits of the law is one thing, but to basically punish certain states for crimes or for actions taken 45, 50 years ago is an anathema to me personally. There are protections under the Voting Rights Act that exist today and I believe should remain intact. And if they can find a formula that is fair and applies to all states fairly, then I would be willing to hear what those proponents of Section 5 have to say. The Supreme Court was right to strike the formula in Section 4, and I supported that. And I would support any prosecution or any enforcement of Sections 2 or 3 against any entity, municipal or individual, who tries to prevent someone from voting at the polling place. But we defended South Carolina's voter ID law. We were successful, and that is something I'm proud of. And I think I've probably run out of time, Fred. I want to thank you for this opportunity, and if we'll answer any questions that you have.
Good. Well, I may ask just one, or we'll see how briefly they answer it or not. And all four of you do not have to answer this question. But my question is, what is your assessment of Attorney General Eric Holder's conduct in office, not personally, not whether he's a nice man or not, but his professional and policy conduct? And don't everybody speak at once.
Well, I'll jump in on a rifle shot answer while the fellows think of the more global answer that is no doubt to come. You know, I certainly have areas I'm very frustrated with the current DOJ leadership in terms of some of the enforcement priorities they've set. And I'll give you one example. It's not perhaps, I'm not suggesting it's unimportant, but it's not one of the great long-term constitutional issues, but as a practical matter for my state, it makes a big deal. Our neighbors to the west are our friends in Colorado. Our friends in Colorado, by popular vote, have decided they wish to legalize the sale and use of marijuana. And that is entirely within their authority, and God bless them. If that's what they wish to do, that's fine. Our folks in Kansas have not made that decision. The conduct that Colorado, by voter referendum and state law, have now legalized remains illegal under federal law. And yet DOJ has made the decision that they're not going to enforce those provisions of federal law in states like Colorado and Washington, which have made a state law policy choice of their own. The problem with that, from the vantage point of the rest of us who live in the neighborhood, is that if federal law is not enforced, we wind up being the importers of all of the product that is sold lawfully in Colorado under Colorado law, is illegal to buy, sell, use, and certainly illegal to ship interstate, and yet the feds aren't enforcing that provision, and we don't have the ability to enforce it outside of our territorial boundaries. And so the net effect is, I was just in western Kansas the 2 days before I came here, the net effect is that our law enforcement officials in the western part of our state, the sheriffs, the police departments, the prosecutors, almost all of which, with 1 or 2 counties exceptions, are very, very small resource-strapped jurisdictions. A lot of law enforcement agencies, literally with 1 or 2 officers in them, are seeing an enormous influx in the amount of product that was purchased lawfully in Colorado is being shipped in relatively large volumes, clearly not for personal use in the sense that most people might think of it, and is ending up in Kansas. And the net effect of that is a huge shift in cost, a huge shift in law enforcement cost from Colorado, from DOJ to the taxpayers in Kansas. So that's an example. They ignore the law and we pay the cost.
Anyone else?
The selective enforcement issue Derek mentions is very problematic in our state too. We've had many occasions to see that in action. One, and the principle involved here, of course, is in the law enforcement world, federal and state law enforcement officials should work together. They should work together as teammates. They do it in many areas, and we've seen more and more in this last 2.5 years of situations where we've actually been informed by the federal government they're simply not going to enforce a law. And not only are we not going to enforce it, if you, in our case in the immigration laws, when sheriffs said we need your help, sheriffs are authorized to pick someone up and call the federal agents and tell them, we have someone you might be interested in. It's a simple example of law enforcement cooperation. The sheriffs were informed by the Justice Department that if you continue to do this, we're going to cut off your funding. We just don't have time for this sort of thing. And that's a very bad signal to send, and it's counter to this tradition of cooperation and law enforcement.
I'm assuming that that case and the marijuana case are decisions that are made unilaterally by Eric Holder.
Kansas wasn't consulted.
Yeah, and I think, Fred, the concern that I have is when you see the Justice Department's recent decision to go, I think, into Louisiana on vouchers. I think that they took a very aggressive approach to challenge the application of vouchers, I think, in Louisiana.
That's right.
And the Civil Rights Division of Justice, I think, has been very aggressive with disparate impact in the banking context as well. So they've definitely been entrepreneurial in their thought process, I think, to the expense of some very important laws that the states have been partnering on for quite some time.
The selective enforcement, as mentioned earlier, is one of the issues that I've had with the Justice Department. I believe it was last year, Florida passed a law that was going to purge their voter rolls of illegal aliens that had registered to vote, and they were basically threatened by the Justice Department on that issue. What was interesting is that it is a federal crime to lie about your nationality when applying to be a voter. So you've got you getting hot and cold from the Justice Department. And another thing that was illustrative, in my opinion, of Attorney General Holder's view and his hyper-partisan view of things was, I'm having gone through the voter ID lawsuit this past year, I look back and look at the context of, in the 2009 election, there were 2 members of the Black Panther Party who were dressed in paramilitary gear, yelling racial slurs, as some would call it, at people who were walking in and using profane language and holding a billy club, and that was given a pass. However, legislatures in states like South Carolina and others passed a law where there's a balancing test done and safeguards put in. That is attacked with the full veracity that you can possibly have in the Justice Department, and that just kind of really set me back.
Do we have any questions here from the audience? Yes, is there somebody with a microphone? You bring it right down here. You don't have to, but if you did identify yourself, that would be good.
Sure. Jessa Bonner from Public Citizen. Thanks for the opportunity to ask a question. So the Attorney General's present here might be aware that a lot of free trade agreements that the U.S. has contains a very controversial provision known as investor state dispute resolution, which allows foreign firms to bypass state court systems and actually challenge state policies through extrajudicial tribunals. And so these provisions have been used to challenge policies in Massachusetts, Mississippi, and California. And in 2002, the National Association of Attorneys General actually passed a resolution against this provision entitled "In Support of State Sovereignty and Regulatory Authority." but current trade agreements that were being negotiated by the Obama administration, such as the Trans-Pacific Partnership and the Transatlantic Trade Deal, actually are on track to expand these rights. And so I'm just wondering if attorneys general have any concerns about the implications of state sovereignty in regard to these trade agreements.
Anyone familiar with this?
I'm not. Are you?
I'm interested. Yes.
Give me one too.
Thank you.
Yes, sir.
John Mashburn, American Civil Rights Union. I just got a question. You don't have any inkling that DOJ is going to do a lawsuit or anything to ship the Colorado marijuana to the school kids in the Filling schools in Louisiana, do you?
I wouldn't think so, but you never know these days.
And then finally, I wanted to ask Mr. Wilson, what's the blob?
The blob. Okay, thank you for teeing that up. You know, I often joke when you talk to groups around South Carolina, but around the country about my view of the federal government's role. I found an analogy that I thought was appropriate from my vantage point. When I was a young child, my dad subjected me to watch, and he's sitting in the back of the room, so I can say this, to watching horrible B movies from the 1950s. There was one movie in the 1950s starring Steve McQueen, and if you're under the age of 40, you have no clue who Steve McQueen is. But I remember watching this movie, The Blob, and in the beginning of the movie, for those of you who remember the movie, an asteroid lands in the middle of a field near a small town. A little ball of jelly rolls out, and a homeless man, that's the size of an orange, a homeless man stumbles upon it, picks it up with a stick, and if you remember what happened, what does the little blob do? It jumps on the man and eats him. And the blob becomes the size of a bowling ball, and then it starts rolling around the town for the next hour and a half, trying to kill Steve McQueen and the town's inhabitants and eating people along the way. As the blob gets bigger and bigger and bigger, by the end of the movie, it is the size of a diner, and it has got all the inhabitants of the town trapped inside. And so, how do they stop the blob? They pick it up and they drop it in the Arctic Ocean, which is what I would love to do to Congress sometimes, but they have to freeze the blob. And the analogy for me is that the blob rolled around as an organism consuming everything in its path. Nothing was going to stop it. It wasn't going to self-contain itself. It consumed and consumed and got larger and larger and larger. The federal government, in my opinion, sometimes, most of the time, is the blob. It just rolls, and it consumes and devours everything in its path, and there is nothing there to contain it, except, in my opinion, the state AGs. We're the Steve McQueen, and our job is to drop the federal government in the Arctic Ocean.
And Alan, he had a pretty cool car, too. He had a pretty cool car, so that's good that we're Steve McQueen.
I knew the blob would come up. Yes, sir.
This is a question about the blob. And it's kind of a broad question, and you folks are really detail-oriented, but this is on the broad side. But years ago, Ed Meese suggested that states ought to have the right to propose their own amendments without going through Congress and conventions and stuff like that. Now, this sounds like kind of a hypothetical, but maybe it's not as hypothetical as we think it is. But I wanted to ask you a general question. If the states had the right to propose amendments without going through conventions and blobs and Congress and so forth, would that increase the negotiating power of the states, even if they didn't use it, just they just had it? Would that increase the negotiating power that the states would have vis-a-vis the blob?
When you say conventions, you mean
states
can pass
states theoretically, according to the Constitution, have to go to a convention and so forth,
right.
and that's been impeding. That's why the states have never used it, because everybody's afraid of a runaway convention. If hypothetically the states didn't have to go to a convention, would and they could just propose an amendment, getting together and agreeing on what the amendment is, didn't have to go to a convention, no chance of a runaway convention. And the states, just like Congress, could propose 34 states got together, proposed one single amendment. Would that actually improve the negotiating power of the states? Because Derek Schmidt mentioned that this is supposed to be a partnership. Would it improve the negotiating?
Yeah, we got the question. Go ahead. Anybody want to respond to that?
Well, I think the leverage question is an important question. I'm not sure how the convention process would play out, but in terms of leverage, what we're trying to do as a group working together is to create keep the government responsible. And I think that ultimately will create some leverage by the states. And what you're seeing in our states, I know in our colleagues here, we've tried to assemble talented people who care about these issues, and it made me think about our staff. We've been able to attract some sharp young people who care about these issues and are going to go back out into the world. Ted Cruz, who's now a famous senator, was the solicitor of the AG's office in Texas under Greg Abbott there. So we're seeing those kind of people, and I think by working together, we're going to be making the federal government think twice before they do these things and leave the policy making to the elected officials.
I mean, I think the structure is there for the states to make it's happening. I mean, Derek mentioned the Casper rule. I mean, it's a hard slog. I mean, that's the challenge. And the velocity of decisions that are being made in D.C. that affect adversely the states and as an extension our individual citizens is obviously quite rapid, you know. And so I'm sure Alan and Derek and Luther would all say that these are difficult cases for us because it takes the resources of our office. We don't contract this out in Oklahoma. We've got the attorneys in our office fighting, you know, for what we believe is right and true right there in the office, and we've got a multitude of cases that we're looking at. So it's difficult to prioritize. It's a hard slog, but it's the right thing to do. I think the structure's there to do something about it. I think there needs to be more responsibility and leadership in Washington to recognize what Derek said, I think, very, very well. We are full partners. And in the instances that we are litigating situations primarily where it is very explicit, either in a statute or the Constitution, the role that we're seeking to preserve. And so, you know, Yogi Berra said about hypotheticals, by the way, you know, predictions are pretty tough, particularly about the future. So I don't know if it's good to answer the hypothetical, but I think that the structure is there for us to do what we can and to make a difference, and I think we are as we're fighting these issues.
And agreeing with what they said, my final thought on that is that I get the feeling, and they may agree with me, that the states have always been equal partners, but we're not seen as equal partners by folks here in Washington, D.C. And that's why you're seeing AG starting to step up and say, wait a second, there's a Constitution here you're ignoring. We are equal partners. You need to recognize that.
We have time for one question, and maybe one of you all can answer this because it wouldn't be time for all four of you to, and that is about judicial restraint. And my question is, has it gone too far to the point where judges, particularly conservative judges, are leaving many excesses of government in place?
I mean, I will tell you that one of the biggest issues, Fred, that we deal with, the Dodd-Frank legislation is reflective of this, is the delegation power. The non-delegation doctrine has really not been, I think, properly enforced by the courts because the courts have tried to show deference and be disciplined to say, you know, if Congress wants to give their authority away to an agency, who are we to step in and do something about it? But Congress is routinely doing that. And Dodd-Frank, the case that Alan and I and others are a part of here in D.C., we need the courts to be assertive, to say, at least with the non-delegation doctrine, you can't delegate your authority, Congress. An agency exists to administer, not create. And we need some curtailment there.
One of the most telling statements in the Affordable Care Act debate was from Chief Justice Roberts when he asked the parties to the states, representing the states, he said, is there anything left the states have not already ceded to the federal government in return for money, in return for other things? Is there any line we can draw there? And that is a very good question, maybe relates to your point.
Good.
Well,
Hans?
that had to be the last question. And I do want to thank the audience for coming, but I want to thank our four attorney generals for taking time from their very busy schedules to come here. And I also want to thank Fred Barnes for agreeing to moderate this because, as I understand it, today is the deadline for getting the next issue of the Weekly Standard out.
I've only written half a story.
So if we could, the audience, please give them a hand. And thank you for coming. That's it. Thank you very much.